Hello friends, this is Dr. Harsha Suryavanshi, Associate Professor from Shri Shivaji Law College, Parbhani, Maharashtra. In previous video, we discussed provisions of Works Committee under Section 3. In this video, we shall discuss about provisions of Conciliation Officer. Conciliation Officer, according to Section 4 of the Industrial Disputes Act, is appointed by appropriate government. The conciliation officer is appointed by notification in official gazette. The primary function or duty of conciliation officer is to mediate and promote settlement of industrial disputes. As regards jurisdiction of conciliation officer is concerned, it is decided by appropriate government and accordingly notified in the official gazette. The jurisdiction of conciliation officer may comprise a specified area, for example, 1 or 2 or more districts. The jurisdiction of conciliation officer may be specified industries, for example, cotton industries or some other kinds of industries. Or the jurisdiction of conciliation officer may comprise 1 or more specified industries. Now let us discuss about procedures, powers and duties of conciliation officer. Section 11 of the Industrial Disputes Act deal with this. Section 11 states that the conciliation officer shall have wide powers to follow the procedure prescribed in the Act. Section 11 subsection 2 says that the conciliation officer may enter into the premises which are occupied by the establishment in order to inquire into the industrial disputes. That means the conciliation officer can enter into the premises of employer and he can inquire into the industrial dispute. However, the conciliation officer is required to give notice before entering into the premises. As regards powers of conciliation officer is concerned, the conciliation officer has power to enforce the attendance of person for examination. That means he can ask a person to appear or attend him and answer the questions raised by the conciliation officer. He can also call for and inspect documents provided the documents are relevant to the industrial disputes or the documents are necessary to verify implementation of any award, or he can call for the documents to carry out any other duty. The conciliation officer shall have same powers as that of a civil court. However, the conciliation officer cannot issue summons and examine the witnesses on oath. As regards procedure of conciliation officer, a landmark judgment is State of Bihar versus Kripa Shankar Jaiswal. In the present case, the conciliation officer did not give notice of his entry into the premises and he entered into the premises without giving notice. The proceedings of the conciliation officer were challenged on the ground that since there was no notice, the conciliation proceedings are invalid. However, it was held by the court that the object of giving notice is to intimate the establishment that the conciliation officer is coming to the establishment and no other stranger. Not giving of notice is merely a technical irregularity and that cannot invalidate the proceedings of conciliation officer. Now let us see what are the duties of conciliation officer. The conciliation officer's duties can be categorized as discretionary duties and mandatory duties. In case of discretionary duties, the conciliation officer, he may try to conciliate or try to settle the dispute in case of non-utility public services. Public utility and non-public utility services are mentioned in the schedule of the Industrial Disputes Act. In case of non-public utility services or non-PUS, we can say that the conciliation officer's duties are discretionary. But in case of public utility services, the conciliation officer has mandatory duties. The first mandatory duty of conciliation officer is to hold conciliation proceedings whenever a notice under Section 22 of the Industrial Disputes Act is given. Section 22 speaks about notice of strike or lockout. Therefore, whenever a notice of strike or lockout is received, the conciliation officer must hold conciliation proceedings. Now, what is he is expected to do? The conciliation officer's second duty is to investigate the dispute as well as the matters relating to the dispute. He shall also investigate the matters or reasons that are affecting the merits of the disputes. He shall proceed for right settlement of the disputes without any delay. The conciliation officer shall induce the parties to come to a fair and peaceful settlement of the disputes. That means the settlement shall not result into injustice to either party to the dispute. The conciliation officer shall try to find out where the parties differ, what are the reasons or what are the points of difference between the parties. If correct points of differences are found out, then in such case the conciliation officer is able to find out appropriate solution. He shall persuade the parties to avoid any conflict. The conciliation officer, after completion of conciliation proceedings, shall prepare a report. He shall send the report to the appropriate government. If he succeeds in settling the industrial disputes, then he shall prepare a report accordingly. The report shall be, or the memorandum of the settlement shall be signed by both parties to the dispute, and the dispute shall be forwarded to the appropriate, disputed solution shall be forwarded to the appropriate government. If the conciliation officer could not come to any settlement, or he fails to settle the dispute, then he shall send failure report to the appropriate government. Now, how the report shall be? Let us discuss it. Section 12, subsection 3 states that the report of conciliation officer shall be signed by both the parties. The report shall contain the steps that are taken by the conciliation officer. What steps the conciliation officer has taken to find out the disputes or reasons for the dispute, and how he succeeded in settling the dispute. If he could not succeed in settlement of the dispute, he shall state the reasons of failure. Thank you friends for watching the video. Let us meet in another video.